Let's move on, viewers. The CAA is once again before the courts. The Supreme Court has decided to hear on March 19 the batch of petitions filed questioning the law's legality and seeking an immediate stay on its rollout. There are several reasons why these petitioners, viewers, have approached the courts. Some of these reasons have been articulated in 2020 by the son of the sitting Chief Justice of India, who is also an advocate. A 2020 video of the speech by Abhinav Chandrachud, the son of Chief Justice of India Chandrachud, has gone viral. In this speech, the CJI's son has raised at least 6 objections to the CAA, calling it ultra virus of Article 14. Now, viewers, this is his belief. Let's put these objections one by one to J. Sai Deepak, another lawyer who has provided an equally articulate defense of the CAA. So on one side, you have Justice Chandrachud's son, who has come out and said the CAA is ultra-virus because it violates the tenets of Article 14 of the Constitution. On the other side, you have J. Sai Deepak, who's going to give us a point-by-point rebuttal. So now let's just walk through each of these objections. The first objection raised by Mr. Chandrachud Jr. is ultra-virus of Article 14. A compelling argument can be made to suggest that CAA is unconstitutional. He says, consider Article 14 of the Constitution, which grants every person, not merely every citizen, the right to equality and equal protection of law within the territory of India. But CAA leaves out many groups of persons. This is what he is saying. Let's get J. Sai Deepak in. J. Sai Deepak, Mr. Abhinav Chandrachud says, this CAA is violative of Article 14. Your response?
So I think the first point that needs to be considered is whether the principles of equality under Article 14 are applicable in the context of allowing people access or entry to Bharat. I think in 2020, I had written an article in the Open magazine addressing this specific issue when the controversy surrounding the CAA was raging and when Article 14 was being raised on a regular basis. Okay. The point is, we must realize that principles of equality under Article 14, when they are sought to be applied in the context of the right of foreigners to enter India, that takes away the sovereign power of the Indian state to take a decision and apply its own security considerations and filters as part of this decision-making process. In other words, when we seek to give asylum or extend our citizenship to foreigners, then the government reserves the prerogative to take a decision depending on its own considerations. And a significant part of that calculus involves security considerations, which is why across the world, even under international conventions, it would be a far-fetched argument to contend that principles of equality under, let's say, national constitutions equally apply to citizens abroad. Of course, I'm bound to be told that since Article 14 speaks of person and not citizens, therefore the rights under Article 14 are equally available. But you must realize that the question of, let's say, access to different parts of the country falls under a specific provision and specific entry of the Constitution, which gives the central government significant prerogative compared to all other aspects of the Constitution. I'll give you a simpler example from an internal perspective. Assume for a moment that somebody wants to enter certain tribal areas in the northeast, or somebody wants to enter certain portions which are seen as portions beyond the ILPs or the inner line permits. Even if you happen to be a citizen of Bharat otherwise, your ability to travel to those parts or your ability to own property in those parts, your ability to marry in those parts, all of these aspects are significantly regulated by the 6th schedule of the Constitution coupled with other legislations. So if these are the restrictions that apply to an existing citizen of Bharat in respect of travel within Bharat to another part of Bharat, to argue that a foreigner has an unfettered right and the right to be treated at par with everybody else as far as access to a citizenship or even refugeeship or asylum is concerned, I'm sorry to say, wouldn't be a right argument. I don't think this holds water, because what people do is that they conveniently paste the provision of Article 14 when it comes to equality and says, look at it, it speaks of equality. I think there was one colleague of yours from the same profession but from a different channel. When the CAA debate was raging, she chose to extract Article 14 on her Twitter feed and say, this is what Article 14 says. So to which a lot of people pointed out, well, going by the plain language of the article, you shouldn't have reservations, you shouldn't have religion-specific laws, you shouldn't have, let's say, schemes and programs which benefit a particular community. How is it that when it comes to those aspects, somehow this express language of Article 14 misses your filters? So that's why Article 14 is a question of application of the law to a specific context. In different contexts, different, let's say, outcomes emanate.
Okay.
That is something that people don't understand. At least, let's say, some people don't understand, which is when you speak of equality, you're looking at equality in the eyes of the law for equals, people who are equally placed.
Okay.
Not all refugees and not all people coming from different backgrounds because of different circumstances are to be grouped under the same class. That is the fundamental argument.
The other objection raised by Mr. Chandrachud is this, that residence required in India is reduced by the CAA. So anyone else who wants to apply to be a citizen of India by naturalization has to reside in India for 11 years. But for somebody who falls within the CAA, the residency requirement is only 5 years. And he takes an example. He talks about Parsis. He said, what if a Parsi flees religious persecution from Iran? That Parsi has to wait 11 years to get citizenship. But a Parsi that he has to flee from Afghanistan gets to become a citizen in 5 years. He said, it makes no sense.
See, again, each of these sublims are dependent on the presumption of Article 14 being uniformly applicable across the board. Once you dislodge the presumption that Article 14 and the equality contained therein is not applicable in the same way as in other contexts, particularly when you speak of refugeeship and asylum and citizenship, then this argument that you must treat an Afghan fleeing Taliban, a Parsi fleeing from Iran, and a Hindu fleeing from Pakistan at par with each other, that is not necessary. There is no such provision. In fact, there are judgments of high courts as well as the Supreme Court which specifically say, in the context of, let's say, refugee ship or asylum ship or the treatment of a foreigner within this country, Article 14's application is very, very narrow, which is to say you can at best question arbitrariness or whimsicalness. But if there are other considerations, those are not even open to judicial review. Okay? So I don't think we need to suffer from this kind of a guilt, because the impression that is being given is that everyone who wishes to flee from a particular situation and seek the asylum of Bharat or seek refuge in Bharat is equally entitled to the same kind of treatment. That is a legally flawed position. There is no basis for it under the Constitution.
What about the fact that it excludes Jews, atheists, agnostics, Muslim minorities, even sexual minorities, like transgenders, for example? That's what Abhinav Chandrachud has said. He says, we have not included atheists, who have excluded agnostics, who don't know whether there is God or not. You've left out Muslims who may be considered minorities in Pakistan and Bangladesh.
So I think what people miss when they look at the CAA with, let's say, a hyper sensitive lens is that they forget that the doors under the Citizenship Act are otherwise open. The only thing is, the accelerated path which speaks of a reduced residency period or domiciliary period for the purposes of grant of citizenship under the CAA, only that is the, let's say, the primary differential. So which means if under the traditional path, you're looking at 11-year residency before you seek to apply for Bharat citizenship, you perhaps are looking at a 6-year period or a 5-year period under the CAA. That is the primary differential. Now, the government may take a position that considering the dire nature of the situation of some of these communities, the situation is such that they have to be extended a special, let's say, treatment or an accelerated treatment. Now, I understand that there's a particular video going on which says that, oh, well, Israel will take care of the Jews. Frankly speaking, that is honestly not a bad argument to make, because that is a country which has been established as a Jewish state, which means India can also lean on Israel to address the condition of certain communities who see Israel as their natural homeland, while India takes responsibility for those people who are seen as the natural, let's say, to whom Bharat comes across as their natural homeland. In this regard, some might say, well, how do Christians of Pakistan treat Bharat as their natural homeland? Because if you see the manner in which they had to convert to that particular religion in order to seek international support at the time of the partition. And you look at how they are treated, and you also look at how they're retained there for not religious purposes, but for caste purposes, because there's a statement, very infamous statement made by the founders of Pakistan, that some of these people have to stay back to clean the toilets of Pakistan. These kind of statements were made. It becomes evident that conversion was an option of force or an option taken out of sheer desperation and it wasn't an option of choice. So let me make this argument very clear. No community or no member of any community can claim equal rights under Article 14 to have access to our Citizenship Amendment Act. Independent of that, they have the right, they certainly have the ability to seek, let's say, citizenship under the conventional path. That door isn't closed to the Jews of Pakistan, to the Ahmadiyas of Pakistan, to the LGBTQ members of Pakistan, to the non-believers and atheists of Pakistan, whoever they may be.
Well, Jesai, Deepak putting his points across. Viewers, these are two sides. You can consider them. We'll try and reconnect right after this short break. We're back in about 3 minutes. Don't go away.